Hello, everyone, and welcome back to the 27th Annual National Security Law Conference here at Duke Law School. We've been having a fabulous morning with some great speakers, and that's going to continue now with my friend, Professor Laurie Blank from Emory University. I really invite you to take a look at her extremely impressive bio it's linked to on the agenda. But just on a personal basis, I can tell you that Professor Blank was, I think, in this area of international law of armed conflict, law of war, much before it was kind of fashionable. And she has built unparalleled expertise. She's the go-to person, not just for people like me, but for the press. She has books out there, and she really is a true intellectual, but I don't invite true intellectuals if that's their only quality to this conference. You have to be a true intellectual and also somebody who can articulate it. And few people are in the category of Professor Blank. She's a great friend, and I'm very much looking forward to her discussion of where we are in terms of the Woomera Manual, if I've even pronounced that correctly. And maybe a little bit of comment on what they're doing up in Canada. But also I asked her, just because it's so topical, if towards the end of her presentation, she gives us some observations about the ongoing conflict in the Ukraine and perhaps some law of war issues that may be arising or not. Without further ado, Professor Blank.
Well, thank you so much, General Dunlap, and I saw Joy in here, and Amanda and Bobby, thanks so much for having us. Really glad that this symposium is on this year. It doesn't feel like a proper year without the Lens conference. So, and thanks to all of you engaging on these issues on a Saturday morning. Lots of important things to talk about. So I'm going to talk about space, and then I'm going to talk also about law of war and some things going on in Ukraine. So international law in outer space. Let me start by talking a little bit about the Woomera Manual, as Charlie mentioned, because you asked, first of all, for me to provide a bit of an update about that and sort of thinking about the law applicable to military operations in outer space. So what is this Woomera Manual? So Woomera is a town in Australia that was where their space industry, not just industry, but their whole space project, their space enterprise. I guess enterprise is the right word when talking about space. Their entire space enterprise is, and a Woomera, I think, is a spear, maybe, in Aboriginal culture. I'm not entirely positive about that, so that's a speculation. What is it? It is a manual, meaning a compilation of what is the existing law on the international law applicable to military operations in outer space. So I'll talk a little bit about that and what is the value? What does it mean to have a manual? What is that? Those of you who study international law might think to yourself, well, I learned what the sources of international law was, and I don't remember the word manual in there. If you study, if you're a 1L or even a 2L or 3L, and you're thinking about different classes you've taken in law school, you've probably heard of, the Constitution and statutes and case law. Again, the word manual probably isn't there either. So what does that mean? And then I'll talk a little bit about just a kind of highlighting some of the issues in thinking about military operations in outer space. And by that, I don't mean astronauts with lasers actually fighting each other in outer space. I will tell you that exactly what's happening in Ukraine, space is definitely involved. And then I'm going to pivot, I guess using that as a nice segue, and talk a little bit about Ukraine because besides the fact that it's important that we pay attention to it for many reasons, including the human context and the human suffering, It's also a great opportunity to just think about some really core law of war things. Okay. So the Woomera Manual is an international group of experts on international space law and the law of armed conflict and the use of force. And it's been a project, I think it started in 2016, and it's looking at how does international law apply to military operations, military uses of outer space, and identifying those core rules of international law and how they apply. This is not making law. States make law. Academics do not make law, much as some might think they do. It is really trying to identify what the rules are. It's taking rules that we know what they are in terrestrial life and trying to think, okay, well, what does this mean when you shoot this law basically into outer space? What happens? How do we think about it? Are there challenges? Are there ambiguities? Are there complexities? The current status of the manual, it's in the final editing and preparation, so keep your eyes peeled. The next step is what's called the state engagement process, which is where the editors of the manual will provide text of the draft to states, and states will digest it, think about it, make comments, and then there will be a lot of discussion. The fact that a state has feedback, has comments, doesn't like something, disagrees, doesn't mean it's going to change in the manual, but it certainly will be taken into account because, again, particularly when we're thinking about customary international law, what states do and what states say and what they think is obviously a hugely relevant piece of understanding how international law works. Obviously, at that point, revisions, finalizing, polishing, all those things we do before publication and dissemination. The goal of this, again, enterprise, I can't resist, is to provide a useful resource for states, for international organizations, for private entities, really for anybody who's going to encounter the questions and issues that might come up in these situations. It's, again, not to make new law, but to try to take a lot of complicated things and at least provide analysis of them in one place. To kind of highlight that a little bit, I thought maybe I would just give a little bit of context for this idea of a manual. What are they for? Why do people get together and spend a lot of time and a lot of energy debating, analyzing, parsing, taking law apart, putting back together, trying to understand what different terms mean, how it would apply? I can tell you, having spent 5 years on this project, it's absolutely fascinating. It's at many times you get to really like get into the essence of being a lawyer and thinking about the law as you sit there and you try to figure out why you and one other person are literally have the same idea and saying the same thing, and yet you can't agree on a particular point of application or particular wording. Why not? And you start to peel the things back and try to figure it out. Over time, there have basically been two types of manuals like this. One purports to be a clear restatement of the law. This is what the law is. Here's where we found it from. Here are the sources. Here's how it works. One that I think you must know well is the Air and Missile Warfare Manual is like that. The San Remo Manual on the law applicable to armed conflict at sea. These are great resources. What's the law? How does it work? How do I use it? Another type of manual, which the Woomera Manual falls into, is a manual that tries to be a restatement of applicable rules. So very similar, but with a lot, maybe more attention and more recognition of the complexity and ambiguities, because it tends to be in areas that aren't as settled. So seeking consensus on the rules, trying to capture all reasonable views about how those rules apply. In essence, the idea is to present law that is complicated, to try to clarify as best as possible, and essentially provide a almost a menu of options for understanding and implementing it. And then states and other actors can try to understand what, how they think it applies based on that analysis and what is reasonable. The most prominent of these manuals is the Talon Manual. Some of you may have worked with the Talon Manual on cyber. Traditionally, manuals, at least in the last, say, 100 years, last 60 years, have tended to address domains. So there's the one I mentioned on the maritime domain, where, for example, there's existing treaty law and enormous amounts of state practice. So the idea to put a manual together was not to say, oh my gosh, how do we understand all of this? It's, looking forward, we're not sure how it's going to be used, but wow, there's so much, let's try to digest it and make it usable so that people don't have to go diving through all of this state practice and so on. The air domain, there's almost no treaty law specific to the air domain, but there's a lot of state practice, and there's a lot of general law of war and international law that's relevant. So trying to take all of that and apply it, that's the Air and Missile Warfare Manual, for example. Cyber, obviously, no treaty law specific to cyber, right? A lot of uncertainty about how it applies and how we understand it. One of the interesting things about cyber, I think, is the challenge of understanding the development and evolution of customary international law, because while there is a lot of state practice, we don't see it. And states don't tell us what they're doing. They're deliberately not telling us for very good reasons, right? Because they don't want that to be public knowledge. They want to have flexibility, deniability. And once you mention a cyber tool, a cyber vulnerability, a cyber access avenue, that's it, it's closed off, right? It's different from, you use your new fighter jet, well, you can use it again. You drop one type of munition, you have a supply, you can use that same munition again, right? It's not like the people on the other side of that are like, oh, I've seen this bomb before, I know how to deal with this one, but that is what happens with cyber. Space is a little bit a mix of some of these. There is general treaty law, which I'll talk about in a minute. It's quite old, though. The Outer Space Treaty is from 1967, and it is not specific in any way to armed conflict, to the use of force, to military operations, and so there's a lot of uncertainty regarding the application and the consequences of military operations. So the goal is a careful explanation of how the law applies in this specific domain. In general, states traditionally didn't pay these projects much attention. And then after the Air and Missile Warfare Manual, the Swiss government and others created a project that I'm forgetting what it stands for, but its acronym is AMPLE. You might remember what it stands for, but I think it's the Air and Missile Project Legal Education, something like that. But you had academics and others who'd worked on that project training air forces on the law that was captured in the manual, right? Not made in the manual. And all of a sudden, this had an effect because it was being put into practice. The Talon Manual had an exponentially greater effect in a new area, right? Legal advisors and others want something they can reach for quickly when they need a quick answer. And at first, states were like, whatever. And then the first Talon Manual came out and states said, whoa, this is, like, people are really talking about this. People are using this as a resource. Well, if they're going to use it as a resource, we need to have something to say about what's going to be in it. And the Talon 2.0 process had extensive state engagement throughout the process. I think one of the most important things is that a manual like this is only going to be useful and potentially influential. Again, the goal is not to be influential, but to be useful. So it's only going to be productive like that if states who are the primary actors, right, and makers of international law, believe that the manual is focused on what we call lex lata. And I don't know, we haven't had a whole lot of Latin this morning, and we have a bunch of lawyers in a room, and I think it's union rules. We have to do a little Latin. So I don't know if that's the CLE rules, but lex lata, the law as it is. So as long as it is doing lex lata, states are going to find it useful. They're going to respect it. They may not agree, but at least they'll be like, okay, this is something we're ready to engage with. As opposed to lex ferenda, which is the law as it should be, the law as we hope it is, the aspirational view of the law. And states generally look at lex ferenda as something that pointy-headed academics do, and advocacy groups, and like, I don't have, we don't have time for that. That's, that's what you might think so, but, we got to focus on what's real. The process is actually quite interesting. Different manuals do different things, but I'll tell you how we do it in the Woomera Manual. You spend some time thinking, like, what are all the issues? What are all the rules? What are all the areas where we have to think about military operations in outer space? These, in the context of space, and I mean, in certainly cyber as well, you can think of, well, in peacetime, do we do stuff with the military in space? Yep, we do. Okay, so there's going to be rules that think about that area. That's general international law. That's things like the principle of non-intervention and interference and state responsibility and all kinds of things like that. What about the use of force rules? When there's an armed attack, when you can use force in self-defense, all those kinds of things. Yes, space definitely relevant for that as well. Okay, we need to think about those rules. What about actual armed conflict going on? The use of space in targeting and all kinds of different things, obviously. If you use a precision-guided munition, you're using space right there, right? So ever since the first Gulf War, 1991, space has figured prominently in military operations. So then you start to figure out, okay, well, we need to actually do the research and draft these rules. And so everybody takes assignments, right? And then you get together and you sit there and sometimes you put the text up on the screen and you sit there and argue. No, I think there should be a comma there. Well, if you put the comma there, it means something different, right? You sit there and geek out like lawyers, basically. Sometimes it's fun. Sometimes you're like, okay, enough. You go argue that in another room and let's keep moving, right? You get a mix of that. And we then we write commentary. How does the rule apply, right? A black letter rule is basically a sentence, right? The principle of distinction between civilian and military objects applies in outer space. Okay, that's a rule. Good. Well, how do you apply it, right? How do you know what's a civilian object in outer space? How do you know what's a military object in outer space? Well, you got to think about what kind of objects are in outer space. And so one of the really important parts about this process is to make sure you have technical experts. Because I will tell you, when you put a bunch of lawyers in a room talking about military operations in outer space, the only example that ever comes up is shooting down a satellite. We blew up a lot of satellites in the course of this project because I didn't know of anything else that was in outer space. I'd just be like, oh, well, what if there's a satellite? And it's like, okay, but we've already blown up all the satellites. Like, come on, got to come up with something else. So you have people who actually work in space. They're not lawyers, they're space experts. And then you sit there and you have these fascinating discussions where they say, well, what are you trying to get at? And you start to explain the legal question. And then you watch these amazing brains going and being like, oh, okay, so let me tell you about this kind of situation and that kind of situation. And then you say, oh, that's fascinating. I never thought about that, right? We had lengthy discussions. What would perfidy be in outer space, right? Which is essentially feigning protection under the law of war in order to attack the enemy. Well, what does that look like? How do we come up with examples that actually test how the law applies? So it's actually really fun. It's a good reminder that when you're in whatever practice of law you go into, you've got to know the business of your client. You have to understand the substance, the facts, the way things work, because otherwise, how do you provide good legal advice, right? So if the only thing you know about space is that there's some satellites up there and there are ASAT, anti-satellite weapons, but there's a whole lot more. going on there. There are satellites with multiple payloads that launched by different countries, and all of a sudden things get complicated. Okay, let me share a little bit more about some interesting things from space, and then I'm going to talk about Ukraine. So beyond the idea of what's happening, obviously, with the manual, how does this work? Let me talk a little bit more broadly. So space is a strategic and operational domain. It plays a significant role in the assertion of national power through various instruments of power. It also plays a significant role in your everyday life. Anybody here happen to have one of these? Right? You can't use this without space. You can't use that without GPS. You can't use that without all kinds of communication tools that we use. Anybody have a Fitbit? All these different things, right? In terms of the national security environment, the U.S. Defense Department has described space as congested, contested, and competitive. Right? It's a great phrase when you think about how do you write these catchy things, right? Congested, contested, and competitive. It used to be when we began the development of outer space law, there were two actors in outer space. That was it. The US and the Soviet Union. Now it's a much busier place. We have an expanding number of players and objects vying for finite locations and operationally advantageous orbits and capabilities in outer space. If you're like me, you think space is really far away, really, really big, and essentially goes on forever. It's not quite that simple, right? Actually, orbital slots are finite, they're distinct, they're specific, and it's not just this huge infinite expanse. US Space Doctrine calls for both offensive and defensive uses of outer space, both kinetic and non-kinetic space capabilities. The US views space as a military domain and seeks to maintain freedom of operations in outer space. Operations for deterrence, for military operations as needed. And as the number of actors grows, right, in outer space, and the range of capabilities grow, and the number of states developing not just space capabilities, but counter space capabilities, we're going to continue to see increased tensions. And so we see states that had not been in space before. We see private actors now going up into space, right? So lots of interesting questions. And the one naturally that comes to mind, if you happen to be an international lawyer, is what role can international law play in addressing or contributing to this environment? Well, if we think about international law from a very general sense, right, it contributes to and provides shared understandings governing state behavior. Law is about expectations. Law is about understanding what's going to happen when X happens. This is the area of acceptable responses, Y, Z, etc. The goals in really any environment are greater global stability, and legal norms help produce clarity, predictability, and reduce opportunities for exploitation. In outer space, international law applies. General international law, specialized space law, the law of war, the law governing the use of force, all of these apply. And when we think about the types of things we use space for, you can see how it's important that we have this set of rules. So for example, we use space for intelligence gathering. We use it for precision navigation, instantaneous global communication, missile warning, precision targeting. All of those things are critically important, and where you can see that not only your own space capabilities, but your adversaries' counter space capabilities and vice versa are both critically important, but understanding the legal parameters for how you can use them, what you can do in response, and so on, is important. When we think about military activities in space, right, we can kind of group them into a few main categories. Controlling access to space. If you can deny your adversary the ability to use its capabilities in a particular domain, you have gained an advantage in either an actual conflict or a contested situation, right, pre-conflict. Supporting operations on land, sea, or air. That's another, obviously, very important aspect. And again, in the midst of a conflict, if you can deny your adversary the ability to do that, you have gained an advantage. And applying force from space, right? Space-based targeting is still a little bit in the future, but it's not that far off. The U.S. and its partners apply the law of armed conflict to all military operations in outer space where the law of armed conflict is relevant. So we need to have a conflict in order to do that. General space law, right, is also relevant. And let me just briefly give you the general framework. The Outer Space Treaty is sort of the basic framework. It sets forth some core principles, which when you hear these, right, then think about the idea of either armed conflict or a contested situation, competition, adversarial relationships, and what that, how that overlays with some of these core principles, because you could see immediately why there's hard questions and there's tensions and so on. So first, basic principle of space law is that the exploration and use of outer space is carried out for the benefit and in the interest of all countries, and space shall be the province of all humankind. Space is understood as part of the global commons. No country owns any part of space. But if you hear that kind of idea, carried out for the benefit and the interest of all countries, space shall be the province of all humankind, that does not really gel with the idea of sort of countries engaged in conflict or competition with each other. We're trying to marry those two things at the same time. So outer space is free for exploration and use by all states. One of the things that means, in addition to states can send their astronauts up, can do scientific research, can do exploration, can do all kinds of other things. But if we think about that from a different perspective, it also means, for example, right, that the use of satellites for surveillance, right, over another state's territory is absolutely lawful under international law. Okay, under international law, a state's airspace is its sovereign territory, right? So, right, if you were to, want to fly your aircraft over another state in order to engage in surveillance, you either need their consent or you're violating their sovereignty. Those are pretty much the two options there, right? Satellite, however, is in outer space, and there is no sovereign territory in outer space. So that's a really significant difference once you have those capabilities, right? Space law also provides for non-appropriation, right? There are no claims of sovereignty or territorial appropriation in outer space. There's a prohibition on nuclear weapons and other weapons of mass destruction, either in orbit or stationed in outer space. The moon and celestial bodies are exclusively for peaceful purposes. No military bases on the moon, no stationing of weapons on the moon, things like that. Here's another really interesting one when we think about the possibility of armed conflict. Astronauts are regarded as envoys of all humankind. They are protected. That is a special status. Well, now think about this. Many astronauts are military. I think at least early on in the US, all of our astronauts were military. Now, I think it's more of a mix. But now imagine that two countries with space capabilities are engaged in an armed conflict, right? And one or both of them have military astronauts doing something in outer space. Are those astronauts envoys of all humankind, meaning they are protected? you can't hurt them, and if they end up leaving outer space, perhaps unintentionally, deorbiting in some way, and landing on your territory, you've got to give them back to their home country. Or are they military personnel? Because if I look at that through the law of war lens, they are lawful targets at all times in an armed conflict, and they are POWs if I capture them. Well, which one is it? We actually don't know the answer to that question because we haven't had that situation come up. So we haven't actually seen a state wrestle with that and decide whether it's going to view that situation with its space glasses on or its law of war glasses on. Right? Which one are you going to do? I think it's highly unlikely that a state that ends up somehow with a military astronaut of its adversary in its custody is going to say, here you go. No, they're going to say you're a POW, right? I mean, you can anticipate how that one is going to come out, but we actually don't know the answer to that one. So I think that's a really, just one example where we have some really interesting questions. One that doesn't relate to conflict, but I think anybody looking for a journal or other paper topic, what is the status of space tourists, right? I decide to pay, I don't know what's the going rate for going up in one of these SpaceX or what's Amazon's, what's Jeff Bezos's company, whatever these different ones are called. Blue, yeah. You know, whatever it is, I just decide that I'm going to do this. Well, when I strap in and I know nothing about how to pilot this aircraft, I don't know how to do anything in there other than I sit there and I guess I'm prepared to physically manage the G, you know, the G forces and whatever. Am I an astronaut when I'm up there? I don't know the answer to that one either. Was Richard Branson an astronaut with the protections that space law provides in that respect when he was up there? Again, we don't know the answer. Somebody go write a paper on that because, you know, it's an interesting question. Okay, I think what I will do now is turn to, bring us back down to earth and talk about Ukraine for a little while. Because there's, I mean, obviously lots of really interesting and important questions in the midst, obviously, of everything that's going on. So I thought I would use the conflict and obviously we're all closely watching the news coverage of it, just to kind of highlight how we think about the law of war and how it applies, and just kind of walk through the basic process there. So it won't surprise you when we think about why do we have law in war, right? Well, the news coverage is pretty evident why we have law in war. It's to protect people, to minimize suffering during armed conflict, right? Particularly to protect civilians. It's also, right, to protect those who are fighting, soldiers, sailors, airmen, Marines, coasties, guardians. I think we're going to have to come up with an accepted that if we say one, it means them all, because it starts to mean I need added time, right? And it also is designed to enable effective military operations. It's not in contest with military operations. The law and military operations work together. So we see, right, I mean, we see the news coverage. We have had law in war for as long as there has been war fighting between human beings. As far back in history, as far back as we can go, there is some regulation of war. The next thing we think about is, well, when and how does it apply? So we are seeing something that for the last, 20 years when we teach law of war, we've always said, well, we rarely see international armed conflict anymore. But there's two situations of conflict, basically, that the law identifies. It's either international armed conflict or non-international armed conflict. So you either have a conflict between two states, international armed conflict, or you have a conflict that's not between two states. It's a state and a rebel group, a state and a insurgent, two non-state groups fighting against each other. Sometimes you have situations where there's many, many more actors. It's a giant mess. Sometimes you have multiple conflicts going on in one place at the same time. You always have to look at who are the actors, who are they fighting against, and so on. So the situation in Ukraine is obviously between two states. It is an international armed conflict. Now, we want to remember that this international armed conflict between Ukraine and Russia began when Russia invaded Crimea in 2014. Russia has occupied Crimea since then. So there has been a state of international armed conflict between the two countries since then. Okay, belligerent occupation is an international armed conflict. This law has applied the whole time. Nonetheless, obviously the current situation is just obviously a much more heightened situation. One of the questions that's been in the news as we think about who are the parties to this armed conflict, obviously they're Russia and Ukraine, pretty obviously, is, well, what happens when countries, for example, there's reports in the New York Times this morning that the Netherlands is providing 200 Stinger, I guess, anti-aircraft. Is that what? Yeah, to Ukraine. The U.S. is discussing providing weapons. The U.K. has, I think, announced, I'm not sure whether the U.K. is providing equipment itself, but it has announced this morning that it's going to help with the logistics of getting weapons provided by other countries to Ukraine. So what happens? What's the status of these countries? Are they now involved in the conflict? So a very glib answer to the question of if you provide arms to one party to a conflict, does that make you now a party to that conflict? I can always start with my glib answer that there's nothing wrong sometimes with a glib answer, which is, as a general matter, if providing arms to one side in a conflict made you a party to that conflict, we would constantly be in a state of world war. Right? I mean, as a basic, if there's general supply or sale of arms, I mean, think of how much that goes on, how many countries do that to how many different other states and groups. So some days we have to step back and think for a minute. Okay, that one supply, that can't really make you a party to the conflict because then we are just not tracking law and reality. Okay, but beyond the glib answer, right, one of the things that is now relevant, but has again sort of been talked about is this old law that we never worry about anymore is the law of neutrality. And the law of neutrality applies anytime you have international armed conflict. And it is designed to govern the actions of states and the relations between states that are not part of the conflict and states that are. Primarily to keep that conflict from expanding and escalating. That is a common theme of international law generally. Let's try not to have conflict, and when we do, let's try to contain it and not have it get any bigger. So when people, just as my little soapbox moment for international law, when people are like, oh, it's not real, what does it ever do? I don't know, that's pretty good right there as a goal. We want to try not to have war, and when there is war, we want to try to keep it from spreading. I kind of almost makes you want to dare someone to be like, really, what's your problem with international law? Because that sounds like a pretty admirable goal that we're working on. But the law of neutrality governs things like providing assistance to states that are involved in a conflict. So providing arms to Ukraine in this context, yeah, you're not upholding your obligations of neutrality because you're definitely providing assistance to one side. But that doesn't mean you are now a co-belligerent in the conflict. It certainly means that the stuff you're providing can be targeted, right? Those weapons that are on their way to Ukraine. If I'm Russia, I consider those to be fair game, right? To use a decidedly non-legal term. But that doesn't mean that the US or the Dutch or the Brits are now part of the conflict. In general, to become a co-belligerent, you either need to declare war. Back, right, in World War II, we had lots of declarations of war. or active participation in hostilities. Okay, if one of these countries sends troops to Ukraine to fight alongside the Ukrainians, now you're a co-belligerent, you're a party to the conflict. Or, right, some say if you engage in systematic and substantial violations of neutrality over time, that could rise to the level. So that's why there are debates going on right now in the National Security Council, as you may see on the news among the lawyers. What are the legal consequences of providing aid, and how much aid and how extensive to Ukraine, is trying to understand, not is it in the US's interest, I mean, those are the political and strategic questions, but what kind of argument can Russia make about the US's role based on that? What are the parameters of the law, and how do you understand how someone else can make an argument about it? That's good lawyering. Right? It might be frustrating, it might be taking a little bit of time, but it's good lawyering. Because, as you may have already figured out, being in law school, ultimately, a lawyer is a risk mitigation advisor. Right? I mean, no matter what law you practice, you're trying to keep your client from doing something that your client, and your client might be the US government, it might be the US Air Force, it might be a company, it might be whoever, might be a individual, from running afoul of the law and understanding what the consequences of different choices are. Okay. The next question, when we think about sort of big picture how the law of war applies, is, okay, we know it applies, we have an armed conflict going on. How do we apply it to people? What is the status of persons and what are their protections? So we are actually seeing in Ukraine some really interesting things that traditionally, at least for the last however long, but we've been talking about and teaching law of war, we tend to sort of reach back in time to World War II and looking for past big, state-on-state conflicts to pull up these examples. So, first of all, in international armed conflict, the law says there's two kinds of people. There's combatants and there's civilians. That's it. There's no gray area. There's no gaps between them. You're either a combatant, which means you're a member of the regular armed forces, or a couple of other categories that I'll mention, right? But it means you're fighting as your job in the conflict, or you're a civilian. And civilian is defined as anyone who's not a combatant. There's no gap, right? Because I often tell my students when I teach this, if the law said, here's the definition of combatant, and here's the definition of civilian, well, it wouldn't take more, a very large room full of lawyers to be like, oh, well, I can figure out who falls in that gap. And if you fall in that gap, you get no protections. The law decidedly rejects that idea. Okay, so let's think about what's going on in Ukraine right now. We have, obviously, Ukrainian military, and we have Russian military. They're all combatants. What does that mean? It means they can be lawfully targeted at all times, no matter what they're doing, unless they are already detained or wounded and out of the fight. Okay, called being hors de combat. Lawful targets at all times. But we also have, right, the whole swaths of the Ukrainian population who are actively or preparing to take up defense of their homeland. Well, here we get to use another provision of the Geneva Conventions, which says that civilians who spontaneously defend their homeland, who take up arms spontaneously to defend their homeland, their town, their village, their city, etc., from an invading force, are entitled to combatant status. The other thing, the benefit, right, the downside of being combatant is you can be targeted at any time. The benefit is if you're captured, you're a POW, right? Prisoner of war is the highest level of protection for persons who are captured, and equally important, very important in the context of this conflict, is that if you are a combatant and the other side wants to prosecute you for your acts during the conflict, okay, you have combatant immunity, which means that you cannot be prosecuted for lawful belligerent acts during the conflict. So a Ukrainian, I don't know, let's just say one of the Ukrainian members of parliament that we're hearing interviewed, who are now armed with AK-47s defending their houses. I was listening to the BBC this morning and they interviewed one woman who's an MP, member of parliament, not military police. And she was saying that she has a weapon. And the interviewer said, are you going to go out on the streets? And she said, well, no, I'm not going to go out on the streets. I have 3 children. I'm going to protect my home. So if you want to make sure we're remembering the human cost of war, that one, I think, that one is enough as far as I'm concerned. But if in fact, somebody like her, any of these Ukrainian citizens, like civilians, not members of the military, essentially they do the example of figuratively running out of their house with a weapon to defend their home, their family, their town against invading Russian forces. They are members of a levée en masse. They are entitled to combatant status. And if Russia were to try to prosecute them for, say, murder of a Russian soldier, they say, I have a shield of combatant immunity around you. I engaged as a combatant in lawful acts during wartime. You can't prosecute me under your domestic law for murder because I'm immune from that. That's a critically important protection in this context. So we see that at play. Last thing in the last couple of minutes is, what about the conduct of hostilities? How you're allowed to fight? What kinds of things you're allowed to attack? So the law of war sets out a comprehensive methodology